Hey everyone, this is Karen Waksman, founder of Retail MBA, and today we have Rich Goldstein with us. Rich is
Hello.
a patent and trademark attorney. He is wonderful. I've known him for years. I asked him to talk to us today about patents and stuff. I wanted to ask him some very specific questions because obviously I work with a lot of people who are interested in selling their products in retail chains around the globe, and they're selling products online, and they have so many questions about patents that I just decided to have them jump on this call and just work through some of these concerns people have, and hopefully you guys get some value out of it. And Rich, wave and say hi.
Hi, how are you? Great, and I think that's awesome because there's just so much misinformation about patents and so many misunderstandings about how patents work. And I think for a lot of entrepreneurs, it's the thing that they know the least about that could possibly have the biggest impact on their business.
That's wonderful. I agree, and which is why I had you come on the call. So, Rich, talk to me about when to consider getting a patent, right? So, like in my world, people create a physical product. They're thinking about selling to Walmart or Best Buy, Home Depot, or whatever, or they're willing, or they're interested and willing to patent their product for Amazon or whatever. Like, when do you start? Do you start even before you create the product? Is it too late once you develop this product? What if you've already been marketing it out in the world? Like, at what point do you consider patenting a product?
Yeah, great question. So let's talk about first of when it becomes too late. So most people don't realize that once you make the idea public by putting the product on sale or even having a website that describes the product and what it is, that it immediately makes it too late to patent your idea in most of the world. It's still a one-year grace period. So if you've made it public, but a year has gone by, then it's game over. And people don't even realize that there's a grace period. And a lot of times people come to me a couple of years after they've been selling a product and say, product's doing really well, and I would love to get it patented now, but unfortunately it's too late. And I think it makes sense. Like, as an entrepreneur, you're looking to do the things that matter at the right time, and you're looking to save money where you can. And so a lot of times people say, well, let me launch the product first and see if it does well. And if it does well, then I'll patent it. But unfortunately, that's a bit of a trap because a lot of entrepreneurs end up losing the rights to their invention that way. So as the first part of your question, that's when it becomes too late, is when it's public or at the very worst been public for 1 year.
So,
And
so you're saying that somebody created a product they're already selling on Amazon. If they didn't patent it within the first year of it being out in the world, they can't patent it?
correct.
Interesting. I didn't know that.
Yeah.
So basically all new products that they create on Amazon or whatever should be products that they consider moving forward, right? So maybe they created a singular product, it's doing well, they found this out, now they're freaking out, they can't do a patent. The alternative is to adjust the product, make it a newer, better version, and then they can patent it. Would that be the alternative answer for that?
Yeah, possibly. But then consider that their new version will be judged against their old version. Like, is their new version different enough compared to their very own previous invention in order to be patentable? So it's kind of like um, it has to really be different at that point. And then you still won't be able to get a patent for the main concept of what you had on the market for more than a year. So it's a pretty bad situation to be in. And
Wow.
I think the lesson from it is just that um, not that every product should be patented, not that you need to apply for patent on every product that you do, but at least figure out if you want to patent it at an early stage. And then either go ahead and do it the right way, or move on and just recognize that you're never going to do a patent on this, and that's okay. And so it's kind of like, just make the decision at an early stage. Is this something that you care about patenting? And then take care of it, or don't, and don't look back.
So at what point do you figure out if you should trademark? I mean, people are looking for some form of protection. So now you're
Right.
freaking everybody out. Like maybe they did or they didn't get a patent. Now they understand the rules. Like, what do you do? How do you protect yourself in any way? Because I want people to
Okay.
feel like they have solutions here. Because I mean, they did something. I mean, they put the product out there. They don't want to be just completely, in trouble now. What do you suggest?
Yeah, exactly. Well, I mean, just first of all, in terms of like when, like the first part of it in terms of protecting it is it becomes too late at the point that we just described. But the other part of when they um, ought to be considering a patent is it depends. Like if you've invented something that's a whole new concept, it might be really early, like you've just begun to sketch it out and you don't know all the details, you haven't really designed the product fully. Sometimes people will file a patent application on their concept, knowing that they're going to update it as time goes on. So they're basically establishing protection for the main concept while they work out some of the details. So but that really is only the case when you have something that's truly groundbreaking.
Okay.
So you have something where there really hasn't been anything like this concept before, and you want to protect the concept while you develop what ends up being a final product, then yes, you file a patent application at an early stage.
Okay.
But for other people where you know that there are products kind of like it, but you know you're going to design a much better version, then you wait until the product is designed until you pursue the patenting, because it's going to be more on the nuances of what make the product better. So there's that. And then also, if you've gone ahead and you've launched the product and you're feeling it's kind of too late to patent, then by all means, you should be protecting the branding of it. You know, branding is protected with trademarks. Product ideas, product design is protected with a patent, but branding, logos, phrases that you use to promote the product, those are protected with trademarks. So then it probably pays to do a trademark for those aspects.
Got it. So an Amazon seller who's selling online and they're just getting hit hard with competition or people just knocking them off or whatever, they decide to completely revamp something, create a newer, better version. They can at least protect it in some way. I'm hoping that you're saying that's what you're
Yeah,
saying.
exactly. I mean, you protect the branding, you protect the name, so that as people are looking for that name on Amazon, at least others won't be able to use a similar name. And you know, when you have a registered trademark, then you can get brand registry with Amazon, which gives you the ability to stop other people from using a confusingly similar name. And it also gives you some other benefits that don't logically follow from like you shouldn't necessarily get these benefits on Amazon, but for some reason they give you access to certain statistical tools and things like that if you're in brand registry. So there's just some other benefits that Amazon chooses to bestow upon you once you register a trademark and enter brand registry. But at the very least, it's helpful just to be able to stop the competition from confusing your customers into thinking that they are you.
So, okay, people are exploring patents right now. They're kind of early stage. How long does it take to get a patent? Like, so they start the process and what's the process? How long does that take? Can they sell the product while they're waiting? Should they do a provisional? Just kind of break down like what the next steps would be. You know what I mean?
Okay, great. So as far as how long it takes, I mean, it often would take a couple of years to get a patent fully issued.
Okay.
But once you apply for the patent, once you put in the patent application, then it becomes patent pending. And patent pending is a good moment because it means that your priority is established toward getting the patent.
Okay.
And so you see a lot of products out there that are marked patent pending. Those are all people that are in the same situation. They've applied for the patent. The patent office hasn't yet decided if they're going to grant it, and there's more that needs to happen first. But still, they know that no one's going to sneak ahead of them to get a patent. So once you apply, you know that other people aren't going to say, hey, that's a really cool idea. Let me try and get my own patent, because you're already in there with priority.
Okay.
And so like, let's talk about that for a second, because that affects the provisional possibility too. And so when you file a patent application, as I said, initially you get priority. That priority is a function of how well your idea was described in the patent application. So it has to be a well put together patent application to effectively establish that priority. So now there's this other option that people talk about called a provisional application. Now, the point of a provisional application is it gets your foot in the door at the patent office, and it gives you priority, and it gives you a year to then file that final utility patent application, which we could talk in a moment about what that is. The point is it gives you a year to do it more fully. And but again, that priority is only as good as the idea is properly described. So a lot of times people say like, well, a provisional application, you just need to write something up and send it in. And when I've done that, I get back a filing receipt that says your patent pending. And what that is just a false sense of security. It's like you get back a filing receipt and you'll never know until it's too late whether the thing you wrote up was good enough. And the truth is that if someone else files their own patent application and you're ahead of them with your provisional application, then kind of their path toward getting their patent is showing that yours was inadequate. And what people typically write up as their own provisional is always inadequate. When you compare it to what a patent actually is, if you look up patents online and you see what a real patent looks like with the drawings and description, that's actually what the provisional needs to do or needs to be in order to protect it effectively. So a provisional is a good option, but not the kind of half-assed provisional that most people attempt, which is to just write something up and file it and say, I've got my provisional in.
So, okay. So you can also just do a provisional and not do a patent and still feel things out for years. Is that accurate?
Yeah, you can file and that's, I think, the best reason to do a provisional is to feel things out. Is you file it, and then you know that your priority is established if you've done it well, and then you can show it to other people, get a sense of what they feel or how they feel about it, and you could get help on various things like prototyping, design, et cetera, knowing that they're not going to sneak ahead of you in line. But in order to keep that priority, you do need to file the application by the end of the year. But it's an option to just let it go.
Well, I mean, the reason I say that is because some people just don't have the money for a full-on patent. So they can give themselves a year, start hustling, trying to sell, make some cash, and then help yourself along the way. Although, yeah, the year mark is very imperative that you don't mess that up. And then also, don't wait to the 11th month. You know what I mean? To start figuring it out before you
100%.
Because I see a lot of times people are like, yes, I got it. And then life gets in the way. Yeah. And not 11 months later, they haven't done anything with it. And now they have this choice they have to make whether or not they're going to get a patent.
Yeah. And it takes more than a month typically to get it together at, like in general, if someone came to me with a provisional that they had filed 11 months ago, I'd say, no, I'm not touching that with a 10-foot pole. I don't want to be responsible for making the deadline. That's just not enough time for me. I'd normally want to, even on my end, a few months to make sure that I could do everything that needs to be done to do the full utility application.
Understood.
So
that makes sense. So how do you know if your product can be patentable? What if you're private labeling something, or you know what I mean? Or some level of you created somewhat similar of an existing product, but it has some functionality that's different, unique. How do you know? I mean, when do you invest the money and figure this out?
Got it. Well, in general, there's two levels to when it qualifies. One is whether it's the right subject matter, like the right type of thing. And a lot of times that's when people get confused between patents and trademarks and copyrights, and they say, I've got a really cool picture on the front of my product. Can I patent that? And it's like, no, that's content. If it's a picture, that would be a copyright. Or people would say, hey, that's a really cool idea for a book. You should patent that. And obviously, again, that's copyright. That's not subject matter for a patent. Mm-hmm. So to be the right subject matter for a patent, it has to be pretty much a physical product or a process. So it's a physical product that has differences from things that have been done before would generally qualify and be the right subject matter for a patent. And by the way, that could also be like a chemical, like a pharmaceutical or a supplement. And again, it could be a process, which a process could also be software or an app. So it's got to be the right type of thing, the right subject matter. And then it has to be different enough. So in the way we measure if it's different enough is there's two levels. One is called novelty, the other is called non-obviousness. So novelty means just, is it different in some way to things that existed before? That's usually pretty easy to do. Non-obviousness is it has to be something that's kind of outside the range of what people would normally think, something that's not obvious. So even if no one has done it exactly like this before, it can't be something which just fits the range. I mean, maybe you have a certain type of bottle, and then you say, okay, well, I added a flip top to this. And bottles of this configuration don't normally have a flip top. But yeah, that would be obvious because people that make bottles know that you could add a flip top, you could have a screw on top, just because it hasn't been put together exactly like this. If it's kind of within the range of what people in the field would know they can do, that's obvious and that's not patentable. So that's kind of what it needs to be, is it needs to be different enough that it wouldn't be obvious to people in the field in order to get a patent. And sometimes it's a little debatable what's obvious and what's not. And this is often what we argue with the patent office about too. Sometimes they'll call an invention obvious and we'll need to show that is not obvious. But a lot of times when you're just changing the size of something or you're changing the material, that's probably going to be obvious.
Got it. So I'm thinking about my customers. I'm trying to give
Yeah.
you examples. Like I had a guy who created a dog pillow, but it was a unique dog pillow and it crushed in Walmart and stuff like that. Just curious, could you get anything to support that? I mean, or no? I mean, it's a
Well,
dog.
if it's kind of like other pillows, but it just wasn't intended for a dog pillow,
Is there
but
someone
intended
lying on it?
for a dog, then that would be obvious, let's say.
So that's possible?
No, that would be obvious is not patentable. It has
Okay.
to be non-obvious. So it's like, that's probably a good example, is it's like you have something which like it's a familiar structure, but okay, no one has sold it for use with dogs. Probably that's obvious.
Right.
That's
Okay.
obvious and
For
therefore not
humans,
patentable.
it's a decorative, la la la. But just is curious. Okay, so that's one
Yeah,
example.
yeah.
Another one would be lately I've been seeing a lot of supplement companies. So there's a ton of supplements out there, but maybe it's a new um, you know, structure to it or something like that. No way? Or possible?
Sometimes yes, but what happens with supplements is a lot of times you're using an ingredient that maybe no one has used in a weight loss supplement before, but you're using it for its known properties. So you're saying like, well, let me add ginger into a weight loss supplement because it soothes the stomach, etc. Well, ginger is known to be something that soothes the stomach.
Mhm.
And so even if it's not in a weight loss supplement, hasn't been directly used in a weight loss supplement before, you're
Mhm.
using it for its known properties, so that's something that would be considered obvious. But if you're taking something that's not expected, something like, let's say, blueberry extract, and somehow you discover that that helps with weight loss, then that could be something that's patentable.
Interesting. Like people are, lately it's just kind of unique products recreated in supplements. I was curious about that. What about like if it was like a biodegradable product where the whole world is selling something else, and so it's a different formula so that it's biodegradable? Could that be patented?
Yes, well, the idea of it being biodegradable is probably a good example of what's obvious and not patentable. Like you say, like, well, no one really sells biodegradable, medicine bottles. Um, that would be obvious because it's a well-known principle that people prefer things that are disposable to be biodegradable so that they don't have an impact on the environment, even if they haven't directly made medicine bottles out of biodegradable materials. That's probably obvious. But if you have a new formulation that allows it to work where it hasn't been used in bottles before, let's say, then that might be patentable.
Okay. Interesting. Anyway, I just want to throw out some ideas. I was trying to think. Like, I had a client who created a headphones that you can sleep in, but it was a
Mhm.
new version, and I bet she could have, she got a patent for it. So there's just depends on. So I just like throw out ideas for people to think about.
Yeah.
Um, so there's different types of patents you
Mhm.
mentioned, and I'd like to hear about them and like what they're good for. Utility, design patents. There's different ones. Can we talk about those?
Yes, absolutely. So, utility patent is what you typically think of when you're thinking of a patent. You think of someone in the garage inventing something to solve a problem in a new way. I've modified my shovel so that it helps you to better pick through the ice or whatever. Like you've changed the structure of something so that it works better.
Hmm.
That's what a utility patent's all about. It's about those structural differences, those functional differences. It's like what we typically think of when we think of someone inventing something. And again, it protects the structure that's distinct from what has been done before. And so that's most typically what we want when we're doing when we want to protect a new idea.
Okay.
Now, there's also design patent, which is really just about the shape of the product. It's about the ornamental appearance of the product. So it's like you have a bottle that it's not different than other bottles. It just has certain configuration to a certain shape, these ridges. It's not about the function. It's just about the appearance.
Okay.
So you can get a design patent. Design patent costs a lot less than utility patent. Um, and the thing about a design patent, though, is it only protects the appearance. So it's a well-known thing about it for forever. So through my whole career, people have thought like, well, utility patent's better than design patent because for a design patent, you just change the way it looks and it's not going to infringe. And that's been true, except on Amazon, design patents have actually become more valuable than utility patents. And let me explain why.
Okay.
So utility patents, again, are about a concept. It's about functional differences, and the utility patents are a lot more money because there's a very lengthy write-up that goes with each utility patent, and part of that is defining in words what the invention is. It's an invention that has these different components, and when someone has these components, then they would be infringing. A design patent is basically a series of drawings that show the design. It's a bunch of pictures. And the way you infringe it is by having something that looks substantially similar to an ordinary observer, in other words, to a jury. So now let's enter Amazon into the picture here. So if you had a product on Amazon and you saw that a competitor was copying your idea, and you wanted to have them shut down with your utility patent, maybe you did an IP complaint to Amazon, and they, now they would be tasked with trying to interpret your patent, trying to interpret the words of it and the definition and say like, well, this says it has like an annular ring extending around the top neck of the bottle, and then a transition area, and you've got people that are making $10 an hour at Amazon trying to figure out the scope of your patent by reading it, right? Now compare that to a design patent where you did an IP complaint and you're saying, hey, that product looks like mine. That's my design. And now they're just looking at pictures and they're saying like, oh, that looks close, shut them down. And that's literally how it happens. And so design patents provide an easy path for you to shut down someone who is copying your product with a competitive listing. And now again, there's that question of like, well, but doesn't it have to be really close? Like if they make it look different, then it's not going to infringe. But you and I both know, and I'm sure your audience knows, that the reality on Amazon is that people don't get imaginative when they copy your product. They don't say, well, that's a cool product. Let me see if I could design my own in the same spirit of it. No, they just copy the same exact thing. So it's going to look the same, and therefore it's going to infringe. People just copy your product as it is. And so even though a design patent, technically, you can get around it by making it look significantly different, they don't make it significantly different. And so your design patent will be an effective tool at shutting down their listing.
Got it. So, how much does it cost to get a patent? Like if like the differences, like give me a range. I know that it depends.
Okay, yeah, for utility patents more involved and more expensive. I mean, typically north of $10,000 to apply for a utility patent,
Okay.
and expect to spend a few $1,000s more to go through the process to get it approved. Design patent, on the other hand, just a few thousand. Like often. I charge about $3,000 for clients that do multiple projects, or Amazon sellers that I know come to me with different products, over a period of time. So, I mean, expect that it's a few $1,000s and a lot less expensive than a utility patent application.
That's
Um,
really reasonable, actually.
yeah. Yeah. I mean, I think if you have a product that has a distinctive look, and you expect that it could go somewhere, like, you're not thinking like, well, this is a product that I'm probably going to sell $500 worth a month. I mean, it's going to be at least 4 or 5 figures of sales per month. Then to me, it becomes a no-brainer to do a design patent.
Yeah, that makes perfect sense to me as
Yeah,
well. I think that's totally reasonable. So, well, that's really interesting. So you wrote a book on this, right? Is that, I see that
I
in
did.
there.
Yeah, the American Bar Association asked me. Yeah, I mean, I spent a good part of my career going around to different events and speaking and explaining to people how patents work. And I wasn't sure how all that was going to pay off until the American Bar Association called me one day and said, hey, we want a book that explains to everyday people how patents work. And we see that you're out there doing that. And so they asked me to write this book, the ABA's Consumer Guide to Obtaining a Patent, um, which is right here. And it's probably reversed on the image, but that's what it looks like. And you can get it on Amazon. It's like less than $20. And but yeah, I mean, again, I'm really passionate about having entrepreneurs understand this, because I feel that it could be a game changer. And it doesn't take that much to really get a feel for how it works, so that you could decide when you should be applying for a patent and when it doesn't make sense and you should just move on with your business.
Right. I mean, I talked to a lot of my clients about the fact that, like, in retail chains, I don't know the exact percentage, but it's like, half of all products in stores don't have patents because they can't. There's just something about them that they can't. But if you have a product that's interesting, innovative, that's kind of new, hot to the market that no one else is really doing, I mean, you gotta do that really, really quickly. So you want to just jump on that, but you don't have to. But it also gives you peace of mind, right? I mean, just as you're out in the world, the alternative is to just go hard out into stores, out everywhere, get as many people to know about your product and your brand and build it out that way. I mean, that's the alternative way, but if you can stress less,
Yeah, well,
the ability to get a patent, that would be a good idea, I think.
yes, and that's true. And you could also stress less when you just put it out in the world by knowing that you're not going to get a patent on it. So just if you understand it enough to know which it is, like, is this something that I should be patented, that I can patent, or is it something that I'm never going to get a patent on? That in itself has its own beauty, because it's like, if a lot of times what happens is people will take a few steps forward with pursuing their product, but then they'll feel like, oh, I'm not protected yet. Maybe I should. And then someone say, hey, I could get you on QVC. And they'll be like, no, not yet. I'm not protected. So, but if you know that, hey, there's no way to protect this product, and therefore the thing to do is to just go and hit it as hard as you can, there's a certain benefit in that too.
That's what I tell my customers. Like, you know what, if you can't patent it, just blanket the market, so I strategies on how to go as fast, as quick as possible into stores, HSN, QVC, and so forth. And I mean, like, I have clients who, sell HSN, QVC through my systems, and like they're selling like vacuum cleaners and stuff. It's really almost impossible to build that out, with a patent and stuff. So, in that case, has to work extra hard to get his name, his brand out in a different way, but if you can, definitely useful. So if somebody wanted to see whether or not their product's patentable, do you guys help with that as well?
Yeah, I mean, typically the way I start with clients is we do a patent evaluation where we do some research to see what else exists that's similar to it.
Yeah.
And then we take a look at not only if it's possible to patent it, but what would the patent cover? Because, there's a lot of patents that are relatively weak. And the thing that makes them weak is that there wasn't that much different about it to begin with. Like, at the time that they were getting the patent, yeah, there were things that were different about it, but it wasn't things that mattered to the market. Like, it might be that that there were a couple of features which, okay, these were not obvious, and therefore we're able to get a patent that covered the invention as long as it included those features.
Mm-hmm.
But that didn't really matter to the market. The market didn't care about those features. So people looked at it and said, well, hey, that's cool what you're doing. We see your patent is for those couple of features, but we don't need to do it. We like the cool overall idea. And then therefore they can copy it. And then they do. And then the person with the patent says, well, see that? You just changed one thing and you got around my patent and there's nothing I could do about it. And that sucks. Patents suck. But the reality is, what they didn't know in the beginning was that their patent would potentially only cover. And therefore, if you could figure out in the beginning that that I would be headed towards a weak patent, then maybe you don't do it. But sometimes, if the whole concept was new, you can get a patent that covers the whole concept, and then other people can't just change a few things and get around it. And so, part of what I like to do when I work with clients is help them figure that out. Not just can we get a patent, but based upon what's different about it, is it going to be a patent that's worth getting? And so that's our first process, called a patent evaluation.
That makes sense.
Yeah.
Well, so Rich, by the way, the reason I do these interviews is because I'm just trying to help people out. I'm just here to support. I like Rich. I've known him a long time. I've seen him do good work. And so I just, I have them come on and you guys can pick and choose if you're interested in working with them. But Rich, how do they get a hold of you? What's the best way? Would you have a website or an email or something?
Yeah, absolutely. I mean, if you want to do that last thing and explore whether it's a match to work with us on a patent evaluation, you just contact my team, welcome@goldsteinpc.com.
Welcome, hold on, welcome at Goldstein, Goldstein,
PC.com. Exactly. And, if you want to learn more about the process, then there's videos on my website, goldsteinpatentlaw.com. Also we have my book, which is the ABA Consumer Guide to Obtaining a Patent.
Cool.
And,
awesome. Well, thank you so much. I really appreciate you. I hope you guys got value out of this. This is Karen Waksman, Retail MBA. If you want to learn how to get your products in the big chain stores, major retailers, and so forth, check out my website, retailmba.com. Or if you want to learn more about patents and so forth, check out what Goldstein's doing here. Goldstein, what was it? The website?
goldsteinpatentlaw.com.
goldsteinpatentlaw.com. All right. Thanks, everyone. Hope this helped. And click on the link below to subscribe and to continue to get interesting information from us. Bye. Bye, Rich. Thank you.
My pleasure.